Welcome to the second podcast for this week, which is on loan capital, that is, borrowings by companies. So companies will be looking to generate their profits internally, for example, through the products or services that they sell. But they will also usually want to raise funds through shareholders and or borrowings from external creditors. And gearing is a critical issue, and different companies exist with very different ratios of borrowings to share capital. Here we're going to be looking at the legal issues around companies borrowing from external creditors. Section 124 of the Corporations Act, which I did mention in week 2, gives the company the power to borrow, and it can do that by issuing debentures, granting security, by granting a security interest over uncalled capital, and by granting what is called a circulating security interest over the company's property. So Section 124 gives all companies that power. Now, who actually decides how much borrowing that a company has? Well, that's a decision for the board of directors. Unless the power is specifically excluded or limited in some way by the company's constitution. Remember that there is a general power of management vested in the board in Section 198 capital A. And this will cover the power to borrow unless the company has a constitution that expressly limits that power. The ways that a company can borrow is varied. So for example, they might borrow directly from a bank, or they may obtain goods on credit, which is also classified as borrowing. Now, one thing that a company can do that individuals cannot is issue what's called debentures. And when we talk about debentures, it sounds like a fairly fancy name, but it is in fact a relatively simple concept. So a debenture under common law is just a document that acknowledges the indebtedness of the company. So the debenture is the document which shows that the company is indebted to a certain amount to a certain creditor. And that debt can be either secured or unsecured. So that's at common law. Under the Corporations Act, there is a specific definition of debenture given in Section 9, so our dictionary. And this definition describes a debenture as a shows in action that includes an undertaking by a body to repay as a debt money deposited with or lent to the body. The shows in action may, but need not, include a security interest over property of the body to secure repayment of the money. So basically, it's a debt and a document that witnesses the debt. There are exclusions, so have a look at them in Section 9 in the definition for yourself. For example, if you're a bank and deposits which are left with a bank by customers, well, they're not classified as debentures, or cheques are not debentures. In the past, there were a lot of debentures issued by companies to the public in much the same way as shares are issued to the public. This doesn't happen as much today, but debentures issued in this way are still classified as a security, which activates the disclosure requirements under Chapter 6, capital D of the Corporations Act. So that is debentures. Let's look now at secured borrowings more generally. So a company is entitled to grant a security interest pursuant to Section 124. Secured borrowing simply means that the lender is entitled not only contractually to be repaid the debt, but they also have some right to a particular item or items of property if the borrower, i.e. the company, defaults. And this is a right based on in property law. Now, one problem is that borrowers may seek funds from more than one borrower and give security to more than one borrower in the same piece of property. And this is what gives rise to issues of priority. So who gets the first bite out of the property in the event of default by the borrower? So default by the company. Now, disputes about priority have been dealt with by way of public registers, which enable determination as to who has security when there is more than one possible secured creditor, and the timing of the creation of each security. Public registers also enable potential creditors to do checks before entering into loan agreements with security. Now, you'll be familiar with the Register of Land Titles from your property law studies. And more recently, the PPSA and the PPSR were created. So the Personal Properties Securities Act, which will go for short the PPSA, and the Personal Property Securities Register, the PPSR. So if you're interested, you can search the PPSR, and I put a link up on your PowerPoint for that. Now, regarding secured borrowings by companies, in the past we tended to talk about all secured borrowings by companies as charges, and that was prior to the PPSA, so the Personal Properties Securities Act 2009, a Commonwealth piece of legislation, so prior to that act coming in. You will see in the Corporations Act a definition of a charge in the Section 9 dictionary. So Section 9 defines a charge as a charge created in any way and includes a mortgage and an agreement to give or execute a charge or mortgage, whether on demand or otherwise. So a charge includes a mortgage. Now remember from property law that a mortgage is technically a conveyance of land to a lender, with the obligation on the lender to reconvey back when the loan is repaid. And it also includes an agreement to give or execute a charge or mortgage. So all these things for corporate law get lumped into the word charge. Now, prior to the Personal Property Securities Act, the PPSA, we also tended to classify the charges as fixed charges or floating charges. Now, a fixed charge would attach to a particular item of property so that the company couldn't dispose of that property without the lender's consent. A floating charge, on the other hand, covered a class of property, but it didn't attach to particular items within the class. So until a future event occurred, the borrowing company could deal with the property as long as they did so in a way that wasn't inconsistent with the charge. But we now have the PPSA, and under the PPSA, instead of a floating charge, we have what's termed a circulating security interest. So a security over circulating assets. So the PPSA tries to cover under this notion of circulating assets the types of assets that were normally covered under the floating charge. For example, assets that the company deals with on a daily basis, which makes it impractical for the company to give a fixed charge over. Trading stock of the company, inventory, the company wants to be selling it, for example, to its customers. So it's hard to provide a fixed charge over that kind of asset. So a company wouldn't want to grant a fixed charge over this type of asset because you can't have the company constantly going back to the lender asking for permission to sell the stock. Cash is another example. So the PPSA just identifies these things as circulating assets now. It defines them within the PPSA, and you find that what happened previously under floating charges now applies to security interests over circulating assets. So essentially the terminology has changed, but the underlying effect is largely the same as pre-PPSA. So regarding the secured borrowings by a company post-PPSA, a company can still provide security, and if the security asset is land or an interest in land, nothing has changed. It still needs to be registered under the land registration system in order to be effective against third parties. For assets other than land, which is what we're going to be focusing on now in this unit, it was always the case that if a lender wanted to register a charge over non-land property of the company, you had to register it with a register maintained by ASIC. So you could always go and search that register to check if there were any charges over non-land property held by a company. So it would be obviously the creditor that would want to do that search. The PPSA was introduced largely to ensure that all types of registers were brought together, so you only have to search one register. So the ASIC register for company charges was migrated over to the PPSA register. So now the registration of charges and security interests, as they are now called, will need to be done through the Personal Property Securities Register. And the other thing about the PPSA is that it extended the notion of a security interest to many things that weren't previously considered charges or security type arrangements under the pre-PPSA law. So things such as retention of title arrangements and many types of leases were not previously security interests, and therefore they weren't registered in the past. But now a lender/creditor can protect these kind of securities under the PPSA by registering through the Personal Properties Securities Register. Now the PPSA is based on the American system, and it's been adopted in Canada and New Zealand and then subsequently in Australia. So it provides a definition of security interests. Section 12 of the PPSA, so the Australian Act, defines a security interest as an interest in personal property provided for by a transaction that, in substance, secures payment or performance of an obligation without regard to the form of the transaction or the identity of the person who has title to the property. So what that means is that notions of title are no longer as important. The PPSR, so the register, provides for the registration of interests in priority. Some practical things to note. The definition of a security interest is found in Section 12 of the PPSA, and you need to have a look at this section carefully. You'll see, for example, it includes things like fixed or floating charges. The definition of a security interest in the PPSA extends the definition of a security interest to what are called retention of title arrangements. I'll refer to them as ROT arrangements, and many other types of leases as well. So go and have a look at the definition of a security interest in section 12. Just to illustrate an example of an ROT arrangement, let's have a quick look at a relatively recent case about these kind of arrangements and security interests. So the case is on your PowerPoint at dot point 1. So we're looking at central cleaning supplies. So in this case, the cleaning company had purchased cleaning products on an ROT arrangement, so retention of title arrangement. There was not registration of those arrangements under the register. The cleaning company went into liquidation, and the supplier, of course, wanted their products back. The liquidator said no to the supplier because they hadn't registered their security interest on the PPSR. The supplier argued that they didn't need to be registered because it was a transition arrangement that happened during what was a 2-year period of time when you didn't have to register ROT arrangements. So there was a 2-year transition period where you didn't need to register interests that were not previously required to be registered under the legislation. The liquidator said, yes, that's true, that there was this transition period, but the supplier hadn't entered into the ROT arrangement 2 years ago. Without going into too much detail, the supplier had an original contract, but they entered into fresh contracts with new contractual terms after that time that weren't actually covered by the 2-year transition period. So in other words, what this case tells us is that ROT arrangements, so retention of title arrangements, need to be registered as security interests on the register to be enforceable. The definition of a security interest under section 12 of the PPSA extends to retention of title arrangements. This is an important point for you to grasp. Now, the second point on the PowerPoint is also very important because it reflects changes to the definition of a PPSA lease that actually came into effect on the 20th of May 2017. So the definition of what is a PPS lease that needs to be registered has changed. Prior to the 20th of May 2017, Section 13 of the PPSA provided for the need to register leases of goods which were for a period of more than 1 year. Now, importantly, if you have a lease that was entered into prior to the 20th of May 2017, this still applies. If you, for example, entered into a lease for more than 1 year, so for example 18 months, and that lease was entered into prior to the 20th of May 2017, then it needed to be registered on the PPSR to be an enforceable security interest. So this hasn't changed for leases entered into prior to the 20th of May 2017. So that definition of a PPS lease being a lease of goods which were for a period of more than 1 year has not changed for leases entered into prior to the 20th of May 2017. The recent changes are effective as of the 20th of May 2017, and I've put them on your PowerPoint for you. The minimum duration of a PPS lease has been extended from more than 1 year to more than 2 years. So if you have a lease entered into from the 20th of May 2017 onwards, that is for more than 2 years, it needs to be registered under the PPSR to be an enforceable security interest. Now, another important point to note is that leases of an indefinite term, so leases of an indefinite term will not be deemed to be PPS leases unless and until they run for a period of more than 2 years now. So what this means is if you have an indefinite lease, you don't register it under the PPSR until you hit that 2-year mark, because then it falls within the definition of a PPS lease under Section 13. So then you need to register the lease if it continues to run after the 2-year mark. So if you have a lease which is for an indefinite term, it will not be a PPS lease until it has run for a period of more than 2 years. The main benefit to retention of title suppliers or lessors under the PPSA, so the Act, is that it provides clear rules to be followed in order for retention of title suppliers or lessors to protect themselves in the event of a buyer's or lessee's default or if insolvency occurs. But the secured party must register their security interest in the property supplied or leased on the PPSR. So this is a central point. Under the PPSA, so the Act, retention of title suppliers and also lessors enjoy the benefit of what is known as a PIMSI, which is a super priority. This means that a registered security interest of a ROT supplier or a lessor, if the PPS definition of a lease is satisfied, that I just went through before, takes priority over all other, including earlier security interests, in the collateral where the requirements of the PPSA have been complied with. So I'll say that again, it's an important point. So because ROT suppliers and lessors enjoy the benefit of what is known as a super priority, a PIMSI for short, it means that a registered security interest, so if a ROT supplier or a lessor registers their security interest in the way that they're required to under the Act on the register, it means that their security interest takes priority over all other, even including earlier security interests in the relevant collateral, where the requirements of the Act have been complied with. So you can see how a problem-solving scenario question on, for example, an exam will require you to assess the priority of different security interests over time. And if you've got a PIMSI which has a super priority and the registration requirements have been complied with by the lessor or the ROT supplier, then their security interest can take priority even over earlier registered interests. Okay, let's have a look at the third and fourth points on your PowerPoint. An interest of a lessor under a PPS lease meets the definition of a PIMSI, so a purchase money security interest. And Section 14 of the Act tells us that. And Leases of a financing type, so for example, where at the end of the lease the property automatically transfers to the lessee, will also be within that definition. So you need to go and have a look at the definition of a PIMSI, that is a purchase money security interest, in section 14 of the Act. So these types of security interests are referred to in the Act as a PIMSI because the security interest is created over the collateral to enable the grantor to buy the goods. Okay, so have a look at that definition in section 14. It's an important one and you'll need to understand it for your exam. So the key thing to remember about PIMSIs, purchase money security interests, as defined in section 14, is that the usual priority rules don't apply here. That is, that the one who registered first in time on the register doesn't necessarily have first priority. Now, if this wasn't the case, then anyone who had registered early, and for example, they had taken a general security interest over the whole of the company's assets, they would have priority over someone who, for example, supplied goods to the company more recently on a retention of title arrangement. So you can see that that actually wouldn't be fair. So PIMSIs, as defined in section 14 of the Act, if registered correctly, get a super priority over other interests, even interests that were registered earlier in time, as long as they comply with the registration requirements. Now, I know this is all complex, and you do have a tutorial question which covers this all in a practical sense. Okay, so note that a PIMSI is broader than the type of leases that I was just talking about. So where the lease is the financing type and at the end of the lease the property automatically transfers to the lessee. I'd suggest that you go and have a look at the website that I put the link there at the bottom of this PowerPoint. So it's the PPSR website, and they have a really good explanation of what I'm talking about. And they also provide you with 4 common scenarios or categories of PIMSIs and provide really clear explanations of each. So we know that a PIMSI is a particular type of security interest, isn't it? So a PIMSI is distinguished from a standard security interest in 2 ways: the manner in which it's created and the priority that it receives relative to other interests in the same collateral. And that's what I was just talking about, that super priority. Now, it's important to note that generally speaking, a PIMSI will not arise in property that the grantor intends to use for personal, domestic or household purposes unless the asset is what's called a serial numbered good or property. So serial numbered goods include things like motor vehicles, boats, etc. So as explained on the website that this PowerPoint refers you to, a PIMSI is likely to occur in 4 different types of scenarios. So the first is a loan or credit to purchase personal property. And this is where funds are provided by a financer or other lender to a grantor for the purchase of personal property. Now, this is the most common transaction that gives rise to a PIMSI and covers purchases of motor vehicles where finance is provided at the point of sale. The second common scenario is where you have personal property advanced to the grantor with an outstanding debt. Okay? So a PIMSI will arise where the secured party has advanced personal property and all or part of the purchase price remains outstanding. And the most common transactions in which this occurs are retention of title arrangements, so ROT arrangements that I was talking about when we were looking at the previous PowerPoint. So this typically involves the transfer of possession of the collateral, with the title only passing after the full payment price is paid. The third common scenario that can give rise to a PIMSI is the interest of a lessor under a PPS lease. And I've also already talked to you about the definition of a PPS lease and how that's changed as of the 20th of May 2017. So this change that took effect on the 20th of May extends the minimum duration of a PPS lease from more than 1 year to more than 2 years, as I've already said, and clarifies that leases of an indefinite term will not be deemed to be a PPS lease unless the lessee's possession extends for more than 2 years. Okay, so any agreements entered into on or after the 20th of May 2017 are affected by that change from more than 1 year to more than 2 years in the definition of a PPS lease. And the fourth common scenario giving rise to a PIMSI is a consignment transaction. Now, a consignment occurs where the title holder, who's called the consignor, delivers possession of personal property to the consignee. The consignee is in the business of selling personal property of that type and attempts to sell the consignor's property. We need to make sure that we are on top of the terminology because this is a challenging area. So under the terminology in the PPSA, so the Act, the following terms are used. So first, collateral. And this is the property which is the subject of the security, so that's quite simple. A grantor is the borrower. In our case, we're talking about the company, aren't we? Who gives or grants the rights to the collateral, that is the personal property, to the creditor, so the granting of the security interest. And finally, secured parties also used in the Act, and that's simply the lender, isn't it? So the person who undertakes the transaction on the strength of the rights to the collateral. So this is the party who needs to register their interest, so the creditor, on the PPSR to protect that security interest that they've been granted. Now, under Section 19 of the PPSA, so the Act, a security interest can only be enforced against the grantor, i.e. the company, if there's what's called attachment of the collateral. Effectively, you have to have had an agreement which gives these rights, which usually isn't a problem. The problem usually arises in relation to what's called perfection. Now, in addition to having attachment of the collateral, the security interest has to be perfected for the lender's or / creditor's interest to be protected against third parties. Now, the usual way that this is done is by registration of the interest on the register under Section 21 of the PPSA. Now, it can happen in other ways, but for our purposes here, it is by way of registering or registration. So who has priority will depend on the timing of the perfection. so the actual registration of the interest on the register, except if it is a purchase money security interest. If the security isn't perfected, it will lose out to those interests that have been perfected, so registered. So in other words, a non-registered interest will lose out to a registered interest. And the key thing about the PPSA is that it doesn't depend upon, as I said much earlier, title to the property. Just because you have title to the property, it doesn't protect you against someone else's priority being higher. One of the earlier cases that makes this clear is the case at the end of your PowerPoint there, so the Maiden Civil case. And in this case, Queensland Excavation Services Proprietary Limited bought some heavy building machinery, and it lent it to Maiden Civil Proprietary Limited, which was a related company. Now, it isn't entirely clear from the facts how they're related, but it is specified that they're related in some way. Now, Maiden Civil would repay the repayment amounts, so the finance costs, to Queensland Excavation Services, plus an extra 10% to cover the profit for Queensland Excavation Services. Now, this arrangement was going along well, but Maiden Civil wanted to loan more money, so they gave a general security over all of their assets to finance company called Fast Finance. So Fast Finance, which is quite an ironic name, now they got in and registered their security quickly. So Fast Finance went in and registered their security quickly on the PPSR. Now, of course, as you can imagine, Maiden Civil then defaulted on its repayments to Fast Finance. So Fast Finance went and appointed a receiver, which we're going to talk about in coming weeks. And they said, well, we're going to take all of the machinery you own because we have a security interest over it that's registered. Queensland Excavation Services said, hold on a minute, we own that machinery, you can't have it. And Fast Finance said, where's your security interest that's been perfected under the PPSA and the PPSR? Queensland Excavation Services hadn't actually registered their interests under the PPSR and therefore didn't have a perfected security interest. Therefore, they lost out to Fast Finance, who had priority. So Fast Finance had first claim to that property, despite the fact that Queensland Excavation Services had ownership of that property. So priority disputes are not resolved by determination of who has title. Rather, it's perfection which determines priority. So these disputes are about priority rather than title. So the priority rules in the PPSA are set out in Part 2.6 of the Act, the PPSA. So subject to minor exceptions, the general rules are these, and I'll put those up on your PowerPoint for you. A perfected security, so a registered one, prevails over a non-perfected security regardless of any notice of the earlier security. Section 55, subsection 3. The first in time prevails in terms of perfection. Now, if both security interests are unperfected, the priority is determined in the order of attachment. Now, a PIMSI, which I spoke about earlier, will take priority over earlier perfected non-PIMSI security interests, Section 62 of the PPSA. Now, lessors and the owners of other personal property that's been hired out or sold to a company need to be very careful to register the lease or other arrangement if it's a hire purchase type arrangement, etc., if they want to obtain maximum protection. So they need to be registered under the PPSA. Also, another thing to keep in mind is that under section 267 of the PPSA, if you don't perfect your security interest and the company enters into voluntary administration or liquidation, which we'll look at in later weeks, then the security interest actually vests back in the grantor, so i.e. the company. So in other words, your security interest as a creditor disappears. And this is because once an administrator or liquidator is appointed, they then have control of the grantor company's property. And the rights of the unperfected security interest holder will be lost. So if this was to occur, it might end up benefiting other secured creditors because they then may access the personal property in winding up the company's winding up process. This is also reinforced by a provision in the Corporations Act, section 588 capital F capital L. And there are numerous cases in Australia and New Zealand, which you can have a look at. We've considered Maiden Civil. White and Spires Earthworks Proprietary Limited is a recent WA Supreme Court decision, which is another case which dealt with those transition arrangements that I talked about when I talked about the Maiden Civil case. Now, the Corporations Act has been amended to take account of the PPSA provisions. Under Section 51 of the Corporations Act, there is reference to a PPSA security interest, which is, as you would expect, described as a security interest under the PPSA. Now, just be aware that the security interest under the PPSA includes both PPSA security interests and a charge, lien or pledge, section 51 capital A of the Corporations Act. And what that means is that the term security interest under the Corporations Act is wider, isn't it? So it also covers land and certain other interests that are not covered by the PPSA. Secured party is defined similarly to cover both the PPSA meaning and a chargee a charge, lien or pledge. Section 51 capital B of the Corporations Act. So I'll just repeat that. So a secured party is defined similarly to cover both PPSA meaning and a chargee, so someone who has the right under a charge, lien or pledge. A secured creditor is then defined broadly in terms of the debt owing to the creditor being secured by a creditor. I'll start that again. So a secured creditor is then defined broadly in terms of the debt owing to the creditor being secured by a security interest. So that's simple. Section 51 capital E. Now, the Corporations Act also adopts the concept of a circulating security interest from the PPSA. Section 51 capital C of the Corporations Act defines a circulating security interest as one that is defined that way under the PPSA or a floating charge. A circulating security interest is defined under Section 340 of the PPSA, and it covers debts from the sale of inventory or provision of services in the ordinary course of business, currency, inventory, a bank account, although it excludes a term deposit, or a negotiable interest. So these things used to come under a floating charge, so the old terminology. Now, the reason why it's important to identify whether or not you have a security interest that is over circulating assets is not only because you need to identify the rights of the grantor to sell the property, but it is also important because there are provisions in the Corporations Act which give these creditors less rights than creditors whose security interest is over non-circulating assets. So under the old terminology, if you had a fixed charge. When a company goes into liquidation, employees will usually get priority, and there are provisions in the Corporations Act that deal with this. And you can have a look at section 561 and section 433. So if there are unpaid entitlements owing to employees, employees will be given priority over funds that are subject to a circulating security interest. And we will deal with this more in the next few weeks. So in summary, regarding PIMSI's purchase money security interests, under the PPSA, the effect of a retention of title clause in a contract will be to create a security interest. Therefore, to protect against third parties, the vendor needs to ensure that the retention of title interest is registered under the PPSA. A retention of title arrangement is part of a special category, isn't it, of security interests known as PIMSI's, Purchase Money Security Interests, Section 14 of the PPSA. And I've already said that generally there is a super priority over earlier perfected security interests if the PIMSI is registered before 15 business days after possession of goods by the grantor, or if it's inventory, when the grantor obtains possession. Section 51 capital F of the Corporations Act is important. So this section defines PPSA retention of title property and then excludes it from the meaning of the term property of the company under the Corporations Act. The effect of this is that a PIMSI holder whose security interest is registered, so in other words perfected, will prevail over an earlier registered interest which is of a general nature. So that just summarizes some of the things that I've been saying. Now finally, then in terms of the Corporations Act, I mentioned earlier that section 267 of the PPSA deems that if there is a voluntary administrator or liquidator appointed, an unregistered or unperfected security interest will be lost and will revert back to the grantor, that is the company, which is under administration or in liquidation. There is a similar provision in the Corporations Act, and this reiterates the old rule that used to relate to the ASIC register. Remember that you had to register your charge under the ASIC register to ensure that you were protected. And this is now found in section 588 capital F capital L of the Corporations Act. If you take a security interest over property of a company, you have to register it or perfect it under the PPSA within 20 business days of the security interest coming into force, or at least 6 months before the commencement of liquidation or administration, or within another time frame if the court extends the time under section 588 capital F capital M. So you have to register the security interests by the latest time of these 3 options. Otherwise, the security interest will vest in the company immediately before the liquidation or administration, and this will mean that the property will become available to creditors generally under the liquidation or administration. Now, it can of course mean that if you have a secured creditor with a properly registered charge, then the effect of this section will be to place that property into the hands of that particular secured creditor. Now, just to confuse things, there are some exceptions in terms of certain types of property, but they're very limited under section 588 capital F capital N. So effectively, this just reinforces what is required under section 267 of the PPSA. The only thing is that section 588 capital F capital L of the Corporations Act imposes time limits on when it has to be done. So you must make sure that you register it within those times, otherwise you'll miss out. Okay, so this concludes the podcast which covers the PPSA and its interaction with the Corporations Act. There are some questions in next week's tutorial which will help you to clarify this law. It is complex, so you'll certainly need to do your prescribed readings and your tutorial questions, and you may possibly need to listen to this podcast again.